of Creative Commons in a specific jurisdiction. This is mostly done for a specific language or languages, depending on the specific conditions and situations of every jurisdiction. The University of Cyprus has been appointed by the Creative Commons as the Creative Commons affiliate in Cyprus for implementing, translating, disseminating and hosting the Creative Commons licenses in Cyprus for the Greek language. Our team works on a volunteer basis and is composed by academics, by law students. Our law students will do the main presentation. By external partners, we would like to build a network of valuable partners in this very important project. And we would like also to invite you to help us to make this reality. I will now give the floor to Mrs. Athanassiou and Mrs. Tzagaraki, who are law students at the Law Department of the University of Cyprus, and they have prepared a very informative, maybe more legal or complex, but we tried to give some examples, overview of what Creative Commons is from a legal point of view, where it stands for, and what main legal issues are included in the process of disseminating a work via Creative Commons.
Thank you, Professor Synodinou. My name is Athanassiou, and we will have an overview of the Creative Commons licenses. Creative Commons is a non-profit organization created in the United States in 2002. It provides the means for the authors in order to help them grant copyright permissions over their work. Before we continue, we should clarify that the word author, which will be used in our presentation, covers all types of creations. By saying author, we mean the initial creator. So, there are 6 main types of licenses. The attribution by, which means that you have to mention the creator when the material is used and shared. The second one is the attribution share-alike one, which requires that adaptations of the material be released under the same or similar circumstances. Attribution non-derivatives, which prohibits adaptation of the material. The fourth one is the attribution non-commercial, which prohibits the commercial use of the material. The fifth one is the attribution non-commercial share-alike. The last license is the attribution non-commercial non-derivatives, which is the most restrictive one. Beside the 6 main types of licenses, Creative Commons also offers a way to release material into the public domain through the Creative Commons Zero Public Domain licenses, a legal tool for waiving as many rights as legally possible. The licenses exist in 3 formats: readable by machines, the common deed, which is readable by humans, and the legal code, which is readable by lawyers. Only the common deed, only the legal code is binding and not the commons deed. So a non-lawyer has to be very careful because they might be misled by the more general and simplified terms of the commons deed in comparison to the more detailed clauses of the legal code. We must emphasize that the Creative Commons licenses are not an alternative to copyright, but work alongside copyright. It provides the means for the authors to make a passage from the system of all rights reserved to some rights reserved one. Creative Commons licenses are drafted to be internationally enforceable. The licenses were first brought to court in 2006 in Holland in the case of Curry against Audax. In this way, Creative Commons were used for the first time as a cause of action and found justiciable. From 2006 until now, no court has declared the Creative Commons licenses unenforceable. Another question which arises is whether the Creative Commons licenses should only be translated or have to be ported to each jurisdiction in order to comply with the relevant national rules and principles of intellectual property law. Particular attention should be given to the terminology of national law, having in mind that some concepts may have a different content or scope in each jurisdiction. One of the Creative Commons goals is ensuring that all of its legal tools work globally so that anyone, anywhere in the world, can share their work on globally standard terms. Earlier versions of the licenses, most of the times, had to be integrated in national jurisdictions in order to be enforceable. This latest version, the version 4 of the licenses, though has been drafted with particular attention to the needs of international enforceability. And therefore, they should only be translated. Cyprus will have the version 4 of the licenses translated. The Creative Commons affiliate consists of over 100 affiliates working in 79 jurisdictions to promote and support Creative Commons activities around the world. At the moment, more than 50 jurisdictions ported the international licenses. Now, I would like to give the floor to Joanna.
So, now let us move on to a more doctrinal question about whether Creative Commons constitute licenses under copyright law or whether they constitute contracts. Today, there is a dominant tendency from the academia to approach Creative Commons under a contract law perspective. Traditionally, contracts are considered to be to provide greater protection to the contractual parties, as they are also applied in various relationships, which are firmly distinguished from copyright law. On the other hand, licenses are considered to be permissions to perform or to abstain an action that would otherwise be prohibited by law. So, the question, this doctrinal question, should be considered as a question of substance, as each legal field provides different degree of protection and differentiated legal remedies in case of infringement. Furthermore, one could say that a contract is more binding than a license. In the case Jacobsen versus Cager, the United States Court of Appeal for Federal Circuit has for the first time regulated about the possible remedies for a breach of an open source license. Although the district court has first held that the relation created between the licensor and the licensee under an open source license should be considered as a relation regulated by contract law, the Court of Appeal has yet disagreed, stating that when the licensee acts in a way that exceeds the provisions of a license that is limited in scope, then the licensor can raise a claim for copyright infringement. If we accept, though, the perspective of contracts, Creative Commons are considered to be unilateral contracts. The unilateral contracts are contracts which are formed by an offer that can only be accepted by performance and not by making a counter-promise. That means that an offeror can make an offer to create contractual relations to the whole world, which in the case of Creative Commons, this might be all the possible future users of the licensed material. As far as the promise of the offerer is concerned, the offerer makes a promise to waive some of his copyright in order to enable the free use, distribution, and edition of their work, while the public itself does not promise that they will definitely use their work. Creative Commons, furthermore, it could be argued that they meet the requirements set under the Cypriot contract law in order to be considered as valid contracts. Firstly, both principles of offer and acceptance are met. The offer is made at the exact time when the offerer applies the legal tools of the Creative Commons to the licensed materials, while on the other hand, the licensees start acting within the scope of a license in order as a form of acceptance of the license terms. Secondly, consideration requirements are met too. Consideration is a prerequisite in the formation process of a contract, and it is most of the times defined as the bargain between the parties, which takes economic value. However, the fact that the Creative Commons licensed material are available to the public for free has troubled many academics about the existence of consideration between the parties of the licensor and the licensee. Although there should be recognized inherent motives in the public licenses, even when profit is not immediate. Thus, in the previous case, the Jacobson versus Cager, it has been regulated that the fact that the lack of direct profit should not consequent to no economic consideration, as the recognition gain, the reputation gain of the licensor is a valid consideration. So today, there is another trouble. As we all know, contracts can be revocable and irrevocable. So let's suppose that a licensor, an initial author A, decides to disseminate their work under a Creative Commons license in 2010, and today, 5 years later, in 2015, he decides to revoke and stop distributing the work under this license. What is the status of the Creative Commons then, and how protected is the user? Is he left protected to the arbitrary behavior of the licensor? Well, the Creative Commons license are considered to be irrevocable. The revocability of the Creative Commons license lies to the already licensed material, which are used by the users, the licensees. That means that an already existing contract could not be terminated by revocation, and therefore a licensee will always have the right to use the licensed material under the specific terms which made them available in the first place. Furthermore, according to traditional contract law and the principle of privity, a contract abides only the contractual parties and not third parties who did not have taken part in the formation process. However, it is ambiguous whether Creative Commons transmit obligation to third parties, especially in provisions like share alike, which obliges the licensees to further distribute the work under the same license, or in case of derivatives. Additionally, Creative Commons do not permit the sublicense of already licensed materials. So it is questionable whether share-alike provisions can be applied. So, could an initial author A sue a subsequent author C for making inadequate attribution to A's name because an intermediate licensee B has failed to attribute A's name, so C is acting in his ignorance? Well, as long as the sublicense is not permitted, the initial author A is in direct relation with the subsequent author C. This means that the license terms follow the license material as they are distributed, creating a downstream chain of bound users. Each modification which is made to a work creates another contractual obligations between the parties, and therefore an unbroken chain of privity should exist between each contractual party. Creative Commons are furthermore considered to be viral contracts for these reasons. However, this chain could be broken by the enforceability of the disclaimer of guarantees and limitation of liability clause, which is inherent in Creative Commons. According to the provisions of this clause, a licensor shall not be found liable for neither the content nor the legitimacy of the licensed work which is distributed. So, if a licensee, due to the use they make, see their computer affected by a virus, that shall not mean the liability of the initial licensor. As you can understand, this raises questions of enforceability too, as in European countries, and of course in Cyprus, there is a huge protection of consumers against the enforceability of such clauses, which are considered to be exclusion clauses. It is ambiguous, though, whether licensees at this matter are considered to be consumers. But in either case, even if this clause is found void, then the legitimacy of the whole license is not to be affected. Creative Commons also incorporate a severability clause, which keeps them intact. Thank you.
Thank you very much, Joanna, for your points. We now move on to moral rights. During the evolution of the licenses, the respect of moral rights protection of work was one of the issues most frequently raised by the Creative Commons community. In fact, the disparity of legislation among different countries caused a twofold problem. First, there are countries that permit waivers to moral rights, which are the common law countries, and others that qualify moral rights as inalienable and thus not susceptible to a renunciation, such as the civil law countries. Second, the application of each moral rights attribute varies across jurisdictions because they are adopting patterns that are more or less restrictive. The moral right is composed by two specific rights. First, the attribution right, and second, the integrity right. The term moral right is not expressly mentioned in any of the licenses up to the version 4. This latest version of the licenses specifically states that moral rights, such as the right of integrity, are not licensed under this public license. However, the Creative Commons has always included clauses assuring the respect of at least the attribution right. So, an example. Photographer A, who is a French citizen, takes a photo and distributes it under a Creative Commons license. User B, who is a Cypriot citizen, takes a photo and adapts it by cutting a mustache from another photo and by adding the design to the final photo. He makes adequate attribution. The United States citizen C uses the derivative work, which is a combination of the initial photo and the second photo, for the creation of a collage and gives attribution to both A and B. A sees the final collage and feels offended and does not wish that his name is connected to it. In France, there is a strong protection for moral rights, while in the United States, there is no strong protection. The answer to this question is that the author who chooses and decides freely to follow the policy of the licenses maintains the powers arising from moral copyright, which is distinguished from the author's economic right. So, first of all, it is mandatory to mention the name of the author. The 6 variations of the licenses are based on the name reference of the author and generally with the reference of the first beneficiary for attribution. Pseudonyms can also be referenced after the approval of the author, of course. However, sometimes the right of recognition of patentity has practical application difficulties because of the multitude of authors, although it is possible technically to refer to the original recipient. Much more problematic is likely to be for the user the possibility of creating a derivative work, and the initial creator considers that the adjustment of modification of the project from the user violates the spirit or the essence of the project and affects the original author's honor or reputation. For example, if a licensee uses a picture and during the modification process cuts a part of it, then the modification which occurred through the cutting act will automatically be considered as an infringement to the integrity right. Thank you very much for your attention.